Hello, everyone, and welcome to Uncivil Law. I hope you are having a great day as always. And we are here today with the decision of the Wisconsin Supreme Court as it relates to one of the many, many, many lockdowns that have been instituted nationwide in this country. So, this court has stricken down the Wisconsin stay at home orders, at least to some degree. We're going to read this opinion, try to figure out exactly what's going on, try to figure out what it might say to broader legal principles beyond Wisconsin. So, a couple items of note here. Obviously, this is the Wisconsin Supreme Court interpreting its own law. So, the law in other states will vary in substance and text. So, the applicability of this may or may not necessarily write on what other people are doing in other states. And also, an item of note is I have generally said that I think these orders are in general lawful. But as the situation develops, that will not be perpetually true. That as the facts change, the rationale under strict scrutiny gets modified. It's an ever evolving factual based test, like many facts tests in law. And as the facts change, the legal analysis changes. So even though these, well, what Wisconsin will say, we'll see. But in my view, a lot of these were legal in the first instance and are becoming increasingly illegal because the facts are changing as we're understanding more and more about this. And I think as a result of that, that's one of the reasons you're seeing a lot of states and localities begin to wind these things down because the legal rationale for putting them in place is becoming more and more tenuous over time. But let's see what the Wisconsin Supreme Court says. Do they think it was illegal in the first instance? Do they think it became illegal? Is there anything here we can learn about general principles that we can apply to other courts and other situations? Let's find out. Let's read this thing and see what's going on. From the Supreme Court of Wisconsin, this came down late last night. As I understand it, the bars in Wisconsin are now open. Sounds nice. So we'll just skip the introduction here. There's about 30 pages of actual opinion. So we'll read the actual opinion. This is original action. Okay, so that suggests to me this was filed directly in the Wisconsin Supreme Court. Okay, that's interesting. So apparently this wasn't on appeal? All right. So this is being written by the Chief Justice of Wisconsin. This case is about the assertion of power by one unelected official, Andrea Palm, and her order to all people within Wisconsin to remain in their homes, not to travel, and to close all businesses she declares are not essential in an emergency order. Palm says the failure to obey this order subjects the transgressor to imprisonment for 30 days, a $250 fine, or both. This case is not about Governor Tory Evers' emergency orders or the power of the governor. So right away, we are seeing that this is being constrained to one particular official at one particular time. These things have to be analyzed on an individual basis. So the power of the governor is still an open question. The power of this random person to do this random one particular order, we'll see what that is, and we'll see if the basis is because this person didn't have authority in law to issue the order, or she went beyond the authority, or what exactly the rationale is. Will be interesting as we try to apply the logic of this to other cases. But as the court is pointing out initially, this is confined to the particular situation with a particular individual. Accordingly, we review the Wisconsin legislature's emergency petition for original action that asserts. So the legislature is filing this, which apparently is a thing you can do in Wisconsin. Okay. And it's an original action being filed in this court as an original case. So the Supreme Court of Wisconsin is the trial court. Fine. The Wisconsin legislature asserts Palm, as secretary designee of the Department of Health Services of the state, broke the law when she issued the emergency order after failing to follow the emergency rules procedures under the law. So she didn't follow the rulemaking procedures. And even if rulemaking were not required, she exceeded her authority by ordering everyone to stay home, closing all non-essential businesses, prohibiting private gatherings of any number of people who are not part of a single household, and forbidding all non-essential travel. So they went beyond the power and went beyond the rulemaking authority and just started doing stuff that you can't, there's a procedure in place. So they didn't do those things. Palm responded that the emergency order that she signed is not a rule. I suppose it's not a rule, so that does make sense that it's not a rule within the meaning of a rule, so it's not rulemaking authority. So yeah, I wouldn't necessarily interpret it as a rule in the first instance, so that argument makes sense. Rather, it's an order fully authorized by the power the legislature assigned. So her argument is she doesn't have to go through the rulemaking process because it's not a rule. That sounds plausible. Let's see what the Wisconsin Supreme Court says. We conclude that the emergency order is a rule under the controlling precedent of this court. Okay, so they say it is a rule within the meaning of Wisconsin law. So if you asked me in the abstract, is this a rule? I'd say no, it's not a rule. It's an effectuation of rules already in place. So it's not creation of a new rule, it's an effectuation of existing rules, or at least that would be the idea. But they say no, this is a rule. Now, whether that's because it's a rule because it went too far or went outside the scope of things, we'll have to see why it is or is not a rule, and why they say it is a rule. What is the rationale for saying it's a rule versus not? That'll be interesting. And therefore, it's subject to the standard emergency rulemaking procedures established by the legislature. Emergency Order 28 is a general order of general application within the meaning of the statute, which defines what a rule is. Okay. So a general order of general application is a rule within Wisconsin law. All right. Interesting. Wisconsin is free to define these terms any way they want. This is the way they've defined it. Fine. According to the rulemaking procedures of this law were required to be followed during the promulgation of the rule. Because they were not, the order is unenforceable. Further, the statute requires that the emergency order be promulgated using procedures established for the legislature for rulemaking if criminal penalties were to follow, as we explained below. So that they have to do a certain process if there's going to be criminal penalties. As part of the notice giving people an opportunity, you have to follow a particular procedure if there's going to be a criminal penalty. Because this official did not follow the law with creating this particular order, there can be no criminal penalties for violating of the order. The procedural requirements of the statute must be followed because they safeguard all people. So far, this is pretty state-specific law. The state of Wisconsin has a particular definition of what a rule is. This falls within the definition of the rule. Therefore, it had to be done a certain way. It wasn't done a certain way. Therefore, it's what we in law community called ultra vires, when we want to sound really fancy. Ultra vires, outside power. So they didn't have the authority to do this. Okay, but that's going to be pretty dependent on the Wisconsin law. So far, the ability of this to read on anything outside Wisconsin is dubious, because you'd have to look at how other states define rules and promulgations and all kinds of stuff. But so far, this is pretty esoteric. Or idiosyncratic might be a better word. We do not conclude that POM was without any power to act in face of the pandemic. However, POM must follow the law that is applicable to statewide emergencies. We further conclude that this official's order confining all people to their homes, forbidding travel, and closing businesses exceed the statutory authorization on which this official claims to rely. Okay, fine. Although, yeah. So far, so good. Hello, Leonard. All right, background. Although we do not address the governor's order, we note for the purposes of background that on March the 12th, 2020, the governor executed an executive order declaring a health emergency in response to COVID. This order proclaimed that a public health emergency existed, designated Department of Health Services as the lead agency, designated them to take all necessary and appropriate measures to prevent and respond to instances of COVID in the state, suspend the administrative rules that the secretary thought would interfere with the emergency response and increase the health threat, authorize the adjutant general to activate the National Guard to respond to the emergency, direct all state agencies to assist in responding to the emergency, proclaim that a period of abnormal economic disruption existed. That's one way of putting it, yes. And directed the Department of Agriculture, Trade, and Consumer Protection to guard against price gouging during the emergency. So far, so good. As further background, we note that the Department of Health Services, the state designee, POM, issued this emergency order on March 24th, 2020. So we got here pretty fast. We've only been just under a month, which, given what's going on, I don't know how fast that is, but it's still pretty quick. So they issue this authority under the authority of the statute and all powers vested through her through the executive order at the direction of the governor. The emergency order directed all individuals present within the state to stay in their home or place of residence with certain exceptions. It remained in effect until April the 24th. Did I misread that date? Yes, I did. So it's been 2 months. I apologize. March the 24th, not April 24th. On April the 16th, 2020, Palm issued Emergency Order 28, also titled Safer at Home Order. Hilarious. This order was not issued by the governor, nor did it rely on the governor's declaration. Rather, it relied solely on the authority vested in this person by the laws of the state, including various laws. The emergency order commands all individuals in Wisconsin to stay at home or at their place of residence with certain limited exceptions approved by this individual or risk punishment by up to 30 days imprisonment or a $250 fine or both. The order also prohibits all forms of travel except what Palm deems essential. I do like that. I do take note here. The court is throwing this individual well and truly under the bus. They keep referring to her by name instead of by title. And I think they're doing that because they are making a point. It's basically like, you're not supposed to do this, ... Palm. We're talking to you, ... Palm. So I get the sense that they're throwing her under the bus a little bit. It's like, it's because they keep mentioning her by name. Anyways, prohibits all forms of travel except what Palm deems necessary. Did the word Palm need to exist in that sentence? It did not. The word Palm did not need to exist in that sentence. The only reason the word Palm exists in that sentence is because we want to beat Palm to death. Okay, we are going to beat Palm to death now. Order all for-profit and non-profit businesses to cease all activities except for minimum operations that Palm deems basic. Again, did we need to mention Palm? No. We did it because we want to beat Palm to death. Prohibit all public and private gatherings of any number not part of a single household. Declares all public and private schools shall remain closed for the rest of the year. Declare that libraries shall remain closed for all in-person services. Declare all public amusement and activity places closed, regardless of whether indoor or outdoor, except for golf courses with restrictions. The order says driving ranges and miniature golf must remain closed. What do you have against miniature golf, Palm? Miniature golf is awesome. Miniature golf kicks the living crap out of regular golf. Come at me. Continues the ordered closure of all salons and spas. Continues the closure of every restaurant and bar except for takeout or delivery. Palm's on a mission, man. Order religious gatherings to limit gatherings to fewer than 10 people, including weddings and funerals. Imposes a 6-foot social distancing requirement and other stuff. However, on April the 20th, Palm issued Emergency Order 31. It is not directly challenged in this action. In it, Palm established gating criteria. That must be met in order to limit the emergency order's prescriptions. The order has no date and relies solely on the assertion of authority. So Palm, it seems, was getting a hint that maybe Palm went too far and is trying to back end this a little bit. It is Order 28 that's being challenged in the original action. The legislature filed this petition on the same date we issued orders setting a briefing schedule that required a response from Palm. We also allowed numerous amicus briefs to be filed. On May the 1st, we granted the legislature's emergency petition for original action assumed jurisdiction. Whether Palm violated the Wisconsin statutes governing the rules by issuing it without complying with the procedures, and even if they didn't violate it, whether the order exceeds the authority by ordering all persons to stay home, forbidding all non-essential travel, and closing all non-essential businesses. The court heard oral arguments on the 5th, which is 9 days ago. We review this controversy under our original jurisdiction found in the Wisconsin's Constitution, which provides that the Supreme Court has appellate jurisdiction over all the courts and may hear original actions and proceedings. Okay. The Supreme Court may issue all writs necessary in the aid of its jurisdiction. We exercise original jurisdiction when the matter is one that should trigger the institutional responsibilities of the Supreme Court. So the Wisconsin Supreme Court apparently can just decide to hear any case at any time in Wisconsin if they're so inclined. That's kind of cool. Just pull a random criminal case out of the docket for no particular reason, just because we can. You can't do that in the federal system. The federal Supreme Court has defined original jurisdiction and defined appellate jurisdiction. So the U.S. Supreme Court can't do that. Very sad. The purpose of our Constitution, the state Constitution, was to make this court the supreme judicial tribunal over the whole state, a court of last resort on all questions, a court of first resort on all questions affecting the sovereignty of the state, its franchise, or liberties of its people. Sure, fine. The dispute in this case involves where the Secretary Designee of the Health Services issued an order in violation of the law of Wisconsin, an order that impacts every person in Wisconsin, as well as all persons who come into Wisconsin and every non-essential business. Exercising original jurisdiction is appropriate in this dispute. We're doing it because we can. Sweet. Palm has contended the legislature does not have standing to invoke our original jurisdiction for this claim. That's a reasonable argument. That the legislature has standing is a strange idea, but this is state law, so the Supreme Court of Wisconsin can determine who does and does not have standing. So what are the standing rules in Wisconsin? Well, fortunately, the Wisconsin Supreme Court is about to tell me, so that's great. Whether a party has standing is a question of law. Yes, it would be. Wisconsin courts evaluate standing as a matter of judicial policy rather than as a jurisdictional prerequisite. So it's not something that gives us jurisdiction. So that's an interesting idea. It's not something that we need to have jurisdiction, which arguably is true in the federal case, because you have to have a case or controversy. So whether or not someone has standing is probably, I don't know if there's a case that actually says it explicitly, but if you asked me, I'd say that standing is actually a jurisdictional requirement in the federal system. I don't know if they've ever said one way or the other, but here they're saying, at least as to our law, it's not a jurisdictional requirement. Standing, not standing, it's just a nice to have. Okay. In Wisconsin, it's a nice to have. All right. That's a thing. One has standing to seek judicial review when one has stake in the outcome of the controversy as affected by the opinion of this controversy. It's Wisconsin's Supreme Court. Wisconsin gets to define its standing rules for its state any way it wants. So why is this the law? Because the Wisconsin Supreme Court says it is. Yeah. It's the voice of God, right? It's Vox Dei, man. Vox Dei. It's the voice of God. It's true because we say it is. Great. The crux of the legislature's claim is that the emergency order was promulgated without following the statutory procedures applicable to the emergency. And in doing so, Palm infringed on the legislature's constitutional core power and its function. You went beyond what the legislature authorized. The legislature's claim is grounded in the concept of separation of powers that's inherent in the Wisconsin Constitution. And all the constitutions, pretty much. We've previously concluded that petitioners have standing to sue when, as legislatures, they claim a member of the executive branch has invaded their core power. This would definitely not fly in the federal system. This would absolutely 100% not fly in the federal system. This Congress wants to file a suit because they're salty about something the governor's doing or the president is doing in violation of their statutes. There's no way that's going to work. No, they've tried. No, that's not going to work in the federal system. But the Wisconsin Supreme Court says, yeah, sure, what the heck, we'll hear that case. Okay. Accordingly, we conclude this legislature has standing to proceed on two claims for which we grant review. All right. Well, you are the people who get to determine that, so it must be true. All right. Standard review. Whether the emergency order fits into a statutory definition of a rule is crucial to determining the issues. We decide whether an action is a rule by interpreting the statute, which defines whether an action is a rule and specifies actions that are not rules. So there's a law that says when something is a rule and when something is not a rule, and treats them differently. Fine. Issues of statutory interpretation and application present questions of law. Yes, they do. The legislature contends that Palm violated the law by issuing the order because the order is a rule, as defined in the statute, and Palm did not follow the rulemaking procedures that were required when it was promulgated. Palm contends the order is not a rule, but rather an order of statewide application, which did not require the rulemaking procedures be followed during a propagation. If the order meets the statutory definition of rule, then Palm violated the law because Palm admits the rulemaking procedures were not employed. Sure. The Wisconsin statute, which defines rule and those actions that are not rules, is central to the controversy. It provides in relevant part. Okay, what is the rule for when something is a rule? What is the rule for rules? Well, here's the rule for rules, at least in Wisconsin. Rule means a regulation, standard, statement of policy, or general order of general application that has the force of law. and is to be issued by an agency to implement, interpret, or make specific legislation enforced or administered by an agency, or govern the organization or procedure of the agency. Rule includes modification of a rule. Rule does not include, and does not apply to, any action or inaction of an agency, whether it would otherwise meet the definition of the subsection that blah, 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 whatever. Okay, so right away, I see the legislature's point in the definition. This is definition specific. So the rule includes a general order of general application that has the force of law, which this seems to on its face. So with this definition in mind, what she did seems to fall within the scope of a rule, because that's the way Wisconsin defined it. Fine. This is what the wonderful thing about having 50 states. You ask me a question about something, I'm like, well, here's what I would generally think is the right answer, and then we go read the specific state law, and it's like, oh, they've defined it differently, because of course they have. So this is how Wisconsin defined it. Is it a rule? It is in Wisconsin. Okay. The legislature argues the order is a rule because it's a general order of general application. Sounds like a pretty good argument. The legislature focuses on the relevant inquiry on to whom the order applies, not why or how it applies. Yeah, okay. I'm not sure the distinction there, but fine. It's undisputed that the order is applicable to every person physically within Wisconsin, whether they're present when the order was issued or not. So whoever happens to be here at any time, you're bound by this. The order is not an order in a contested case, nor an order directed to a specifically named person, or a group of specifically named persons that does not constitute a specific class. So if this were to a particular, I assume the idea here is in the context of health. I assume the idea here is if the Department of Health want to close a particular business for health violations, they could do that, because that's not generally applicable. So if they want even like a group of businesses, maybe even like maybe a city's worth of businesses, maybe wouldn't be. Maybe that's not general enough. So what is general and not is, of course, going to be an issue of state law. But I think we can all concede that what the line between individual business not being and the entire state is, well, this is the entire state. So you went all the way to the far end of the page on this one. So whether or not a group of businesses or entire cities of businesses or entire regions worth of businesses qualify as general or not, we don't have to figure that out, because you went all the way to the end of the page. You issued it against everybody. You made it as general as can be. All the people. That's pretty general. So the line between general and specific, we're not sure, but you went to the far end, so okay. If it were either, it would be exempt from the definition of what a rule is. Fine. The PALM asserts this order is not a general order of general application. Okay, this will be good. Inform me, PALM, why it's not. Because it responds to a specific situation. That's a little tenuous. She states, while an order responding to a pandemic may be a general order because it applies to the population as a whole, it is not of general application because it responds to only a specific limited in time scenario. The limited in time nature of that is also a little suspect, Palm, because how long can this go on? You say limited in time. How limited? Limited by the heat death of the universe? I don't know. Palm also cites a different Wisconsin statute, which states in part that any rule or order made by health may be made applicable to the whole or any specified part of the state. Fair. She argues there has to be some way for an order to be applicable to the whole state without being a general order of general application to the reference of rules is redundant because all general rules are... Let me try that sentence again. She argues there has to be some way for an order to be applicable to the whole state without it being a general order of general application or the reference to orders in the different statutes redundant because all general orders of general application are rules. Okay? Therefore, Palm contends the order cannot be a general order of general application solely because it applies to every person physically in Wisconsin. All right. She also cites a different rule which states that the health services can authorize and implement all emergency measures to control communicable diseases. Question of whether a general order is of general application has been addressed previously. So we know it's general as to who it applies to, but when is it of general application? We addressed the meaning of this term of general application in Citizens for Sensible Zoning. There, the DNR issued, I assume that's Department of Natural Resources, the DNR issued an order which found that Columbia County had not enacted a reasonable and effective floodplain zoning ordinance when it adopted the zoning ordinance for delegated floodplain. Floodplain law. Riveting. Over the next 10 months, the Department of Natural Resources promulgated the ordinance. Citizens for Sensible Zoning sought a declaratory judgment that the ordinance was invalid. The group moved to dismiss the ground that was time barred. As explained, it was not time barred if the ordinance is a rule. All right. Our answer to the question of when ordinance is a rule is defined by the definition of rule, not set out in statute. We conclude that ordinance was a rule because it was regulation of general application. We stated, it's not always easy to determine whether an agency action is a rule and of general application or is a determination which affects specific parties. The Columbia County floodplain zoning ordinance applies only to land within the floodplain in the unincorporated areas of Columbia County. The ordinance restricts the conduct of only those persons with a legal interest in this land, which sounds not that general, but nevertheless, to be of general application, a rule need not apply to all persons within the state. Even though the action applies only to persons with a small class, the action is of general application if the class can be described in general terms and new members can be added to the class. Okay, so it is of, among other things, a rule is a rule if it's general, and it's general if it can be described in general terms and who it is changing on a changing basis. So presumably, all restaurants that are located in a particular city as of this date would not be general within that meaning because it wouldn't add new things to it. It's a closed class, or at least would be a different argument. So this is open because it's all people who happen to be in Wisconsin at any given time, whether or not they're Wisconsinites or not. So it's pretty open. So that makes it general applicability under Wisconsin state law. All right. Yeah. Sure. We explain that a rule for the purposes of the statute is a regulation, standard, statement, policy, or general order of general application, having the effect of law issued by an agency to implement, interpret, or make specific legislation enforced or administered by such an agency to govern the interpretation of the agency. We concluded the floodplain ordinance was a rule. In doing so, our focus was the people who were regulated by the order, explaining that the ordinance restricts the conduct of those persons with legal interest in the property in the floodplain. Our focus was not the type of factual circumstances that led to the order. We concluded that the class of people regulated by the order is described in general terms, and new members can be added to the class, the orders of general applicability. I'm not sure how easy it is to add new members to the class. I suppose people could buy and sell property. It's not quite that dynamic, but apparently it was dynamic enough for Wisconsin. The class of people who are described in general terms of new members can be added when others secure legal interest in the property of the floodplain. I'm not 100% sure I fully buy that idea. Yeah, I mean, who is being impacted by this is technically changing, but it's a fixed amount of land. And yeah, I guess technically, like, who's being impacted by that would change as you buy and sell property. But that makes it an open class. I don't know if I buy that logic. But it's Wisconsin interpreting its state law. So that's the law. That's open enough, I guess. So, okay. I would not be inclined to go that way. That seems a little closed, but okay, fine. The Citizens for Sensible Zoning case has been cited for its application of the statute of the term general application when the challenge is made to an agency action asserting the action as a rule. In Chevron, which when I first saw that, I read a Chevron and I had a gut reaction. I'm like, why is Chevron popping up in a state case? But no, it's not Chevron. Deep breath curve. It's In Scholven, which is not Chevron, different case. The Court of Appeal held that citizens applied to that case. In Scholven, the plaintiff had been receiving Wisconsin Medicaid program benefits. She challenged the instruction giving screeners that hindered her ability to continue receiving the benefits. One of the issues was whether the instruction was a policy of general application and therefore a rule. She argued the policy was of general application because it applied to the entire class of persons who had their eligibility for Medicare waiver program determined by the use of this functional screen. She contended that new members can be added to the class as additional people seek to receive waiver benefits as changes to the fluctuating abilities occur. Okay. The Court of Appeals agreed, concluding the instruction was policy of general application, therefore a rule. As with citizens of sensible zoning in Scholven, the focus was on people regulated, not on the factual context. The class of people was described in general terms and its ability to add new members to the class. Okay. So, as far as Wisconsin is concerned, apparently, we are concerned about only the class of people that are included in it. We're not interested about anything else, whether or not it's a rule. So if it is an open class of people, even if it's otherwise confined, it's a rule. This seems to be the lesson that is taught by these cases. So even though it was, in the case of a floodplain, limited to development on a floodplain, in this case dealing with Medicare recipients who may or may not qualify for whatever, because those are technically open, then it becomes a general rule within the meaning of the relevant statutes. Okay. This is also why I want to once again emphasize that your mileage may substantially vary in other states, because so far we are rendering this decision based on specific aspects of Wisconsin state law. This is pretty specific stuff. This is going right into the heart of various statutes in Wisconsin and how exactly they read and the case law in Wisconsin. So I am not so far seeing any grand principles that are emerging from this case that would inform these orders in other cases. I suppose the degree to which the other states would have language that is similar to Wisconsin, then it would at least be persuasive authority by other states. But there's nothing here that is going to become a rallying cry for freedom everywhere. I'm not seeing a lot of people storming the streets with banners talking about the floodplains. Not really seeing that happening. So this is a little bit esoteric so far. It's a little bit idiosyncratic to Wisconsin. It's pronounced Colvin. Okay. It's pronounced Colvin. And Rio is pronounced as Rio? All right, well, I apologize to everyone from Wisconsin everywhere for mispronouncing various names. We do our best here on Uncivil Law. If we read the definition of rule as Palm suggests, one person Palm, an unelected official, could create a law applicable to all people during the course of it and subject people to imprisonment when they disobeyed the order. Palm has not addressed these cases, yet the precedent decisions directly address whether this is a rule. In addition, both cases stand contrary to the argument that the reason for the order is controlling. Doesn't seem to be, no. Furthermore, both cases note the openness of groups of people regulated. Stated otherwise, people not regulated by the order one day could be regulated the next. In the case now before us, persons traveling from other states, there's that word traveling. Sovereign citizens everywhere should be happy. The Supreme Court of Wisconsin used the word traveling. People traveling, all those sovereign citizens, I guess, from other states become bound by the order when they cross into Wisconsin. We note that the legislative history underlying the law confirms our understanding that the drafters of the language on which Palm relies did not contemplate expanding the Health Services Authority, nor did Health Services understand the amendment to do so. The language creates an issues order language. In the explanatory notes, the Health Services states the bill is basically technical changes. Which is designed to bring the statute into concordance with current public policy and epidemiology throughout the terminology. In 1979, the predecessor statute addressed general orders of general application, showing that health had authority to issue orders in 1979, but that order was a rule that met the statutory definition of the rule. And finally, the Legislative Reference Bureau never described the additional language as changing the authority. Okay. We are not persuaded by Palm's characterization of the order. Her assertion, in response only to a specific limited in time scenario, is questionable. Yeah, it's a little questionable because how limited in time is that, Palm? I'm talking to you, Palm. And it's not relevant to whether it's a rule. Further, a limited in time scenario is not a power that Palm has seized. To explain further, subsequent to Order 28, Palm issued Order 31, which states that Wisconsin shall adopt a phased approach to reopening its economy and society, with each phase being incrementally less restrictive on businesses and individuals while protecting the public from the disease. The Department of Health Services shall announce the transition to each phase with an order fully articulating the activities that will resume. This is the gating criteria, directed repeated extensions of the order until the criteria that Palm established, again without following the procedures set forth for the emergencies as in the rule. Stated otherwise, Palm's subjective judgment is the only limitation in the regulations. Oh, poor Palm. Poor Palm. You are getting destroyed by your Supreme Court. Palm is getting smacked down pretty hard. Poor Palm. It's the Schadenfreude is real. The Schadenfreude at watching Palm get destroyed is very, very real. Yeah, I'm trying not to enjoy it too much. Rulemaking exists precisely to ensure the kind of controlling subjective judgment asserted by one unelected official is not imposed on Wisconsin. Yes, amazingly, we'd like to not have a dictator. That would be great. We recognize that emergency rulemaking procedures contemplate that rules may have to be promulgated in response to extraordinary circumstances. The statute provides that an agency may promulgate a rule as an emergency rule without complying with notice, hearing, and publication requirements if preservation of public peace, health, safety, or welfare necessitates putting the rule into effect prior to the time it would be necessary to effect if the agency complies with other procedures. An emergency rule promulgated under the statute remains in effect for only 150 days, unless extended by the legislature's Joint Committee for Review of Administrative Rules. As counsel for the legislature explained during oral argument, necessarily under this statute, you're dealing with a rule that's time limited, and necessarily you're dealing with a rule that's responding to a new set of circumstances and its perspective. Therefore, this rule is a general order of general application. The class is generally defined, and new members are being added when people add Wisconsin. We also note that the Wisconsin statute contains 72. We also note that the Wisconsin statute contains 72 specific exemptions from the definition of rule. The Wisconsin legislature was very, very thorough on what they do and do not want to be a rule. They create 72 exceptions to their own rule. It's very well defined. You shine on, Wisconsin legislature. Some of these exemptions apply to health services. For example, health services actions regarding computing or publishing the number of nursing home beds to be added in health planning under the rule are exempt from the rule. Okay. Some exemptions relate to orders. However, despite the detailed nature of the list and the legislature's consideration of acts and health services consideration of orders, no act or order pursuant to this rule is exempt from the definition of a rule. In addition, we employ the constitutional doubt principle. Okay. That is, we disfavor statutory interpretations that unnecessarily raise serious questions about the statute in consideration. Yeah, this is pretty common in federal courts. You try to, the constitutional avoidance doctrine, they call it something different in Wisconsin. What they called it the constitutional doubt principle. In federal law, we call it the constitutional avoidance principle. Same exact thing. As a general principle, we try to avoid reading statutes in a way that would conflict with the Constitution. As a general rule, we try to avoid reading conduct that occurs in such a way as to avoid the conflict with the Constitution. We try to avoid the constitutional conflict as much as we can. So Wisconsin does the same thing. They want to avoid reading it to conflict with the state constitution if they can. Okay. Pretty common. Palm points to statutes that she asserts gives up the broad authority to impose a regulation, but does not follow that she can impose this regulation without going the process to give people faith to justice. Yes, you have the authority to do stuff. How you do stuff is what we're talking about. That is the relevant issue. Yes, you have the authority to do stuff. How you're doing it is what we're concerned about. However, under Palm's theory, She can implement all emergencies necessary to control communicable disease, even at the expense of fundamental rulemaking, even at the expense of fundamental liberties without rulemaking. Ouch. Ouch. That stings. That stings. It stings because it's true. Under Palm's theory, she can implement all emergency measures necessary to control diseases, even at the expense of fundamental liberties. That may be a bridge too far, Palm. Did you look at yourself and be like, that might be a problem? Okay. That interpretation is constitutionally suspect. You don't say. We do not constitute this statute as an open-ended grant of police powers to an unconfirmed cabinet secretary. The statutory construction affords a sweeping delegation of legislative power, has potential to cause constitutional problems in further cases. To explain further, Article 1, Section 1 of the Wisconsin Constitution, right at the top, we put it at the top. All people are born equally free and independent and have certain inherent rights. Among these are life, liberty, and pursuit of happiness. To secure these rights, governments are instituted, deriving their just powers from the form of consent of the governed. We're ripping off the Declaration of Independence, but that's okay, I guess. The people consent to the legislature making laws because they have faith. The procedural hurdles required to pass legislation limit the ability of legislatures to infringe on their rights. It is one of the good mechanisms of liberty. Yes, the structure, and Justice Scalia gave a really wonderful, I guess I'd call it talk, for lack of a better description, in front of Congress one time under oath. He was on a panel, as is not infrequent. They are there for various reasons to talk about the judiciary, and he gave this really great, like 8-minute long talk. If I can find it, maybe I'll put it in the comments or put it in the description. But he gave this really nice comment where he said what he thought really was the fundamental guarantee of liberty was not the Bill of Rights. And the reason he said that was because, well, the Russians had a wonderful Bill of Rights, in some respects arguably better than ours, but it was a paper guarantee because it didn't really mean anything. So what he said was the best guarantee of liberty was the checks and balances structure that was created. It's the tension between the various branches of government, and the very fact that you have to go through a legislature and it has to be this slow, deliberative process is itself a check to prevent breaches of liberty. So I thought he had a very good point, and that these structures that we have in place are in large part a reason that we have liberty. And so they're saying, well, there's allocation to the legislature here that you're usurping. That's bad. You're not allowed to do that. You can't do that, Palm. The limits include bicameralism and presentment. It has to go through 2 chambers. It has to go to the governor, who has to sign it. And also include quorum requirements and journal and open door requirements. It has to be open to the public. At times, legislation is enacted that infringes on a person's right despite these front-end procedures. However, for that, we have judicial review. Yeah, so it's not the end-all, be-all, but it is a serious protector of liberty. And sometimes the legislature goes too far, and for that, we have courts. But we shouldn't take for granted the structure that's in place. We have allowed the legislature to delegate its authority to make law to administrative agencies. But we've stated in a case, Martinez, that such delegation is only allowed if there's adequate standards for conducting the allocated power. Stated otherwise, a delegation of power to a subordinate agency will be upheld if the purpose of delegating statute is ascertainable, and there are procedural safeguards to ensure a board or agency acts within the purpose. When a grant of legislative power is made, there must be procedural safeguards to prevent the arbitrary, unreasonable, or oppressive conduct of an agency. Palm cannot point to any procedural safeguards on the power she claims. Palm wants to be Caesar, man. Palm for Caesar. Palm for Caesar. Yeah. At oral arguments, she continuously referred to judicial review, but judicial review takes place after an allegation is made that rights have been violated. This is why our case law constantly speaks of procedural and judicial safeguards. Rulemaking provides ascertainable standards that hinder arbitrary or oppressive conduct. Judicial review does not prevent the conduct from initially occurring. Furthermore, the executive order purports to criminalize conduct pursuant to law, when a factual derivative law is transgressed. For example, the order purports to impose a 30-day in jail when a person leaves their home for a purpose that Palm does not approve of. Palm is getting destroyed, man. I feel just a little bit bad for Palm, but still, the shameful joy element is very, very real. Palm is getting her ass handed to her right now. Oof. In order to constitute criminal conduct prescribed by statute, the conduct must be set out with specificity to give fair notice. The same specificity is required in a promulgated rule before criminal sanctions could follow. Both must meet the standards of definiteness applicable to statutory definitions of criminal offenses. It has long been the law of Wisconsin that in order to violate an administrative agency's directive to constitute a crime, the directive must have been properly promulgated as a rule. Palm asserts the order is not a rule, yet she also asserts that the statute empowers her with power to create criminal penalties for violation. Her argument stands the statute on its head. This is because the criminal statutes arising from a rule violation only apply when a rule was properly promulgated. So it's not a rule, but I still want criminal penalties anyway. Okay. Without the promulgation of the rule, no criminal penalties are possible for a violation of a directive. Notwithstanding the law, Emergency Order 28 does not rely on the statute within defining the crimes that are punishment. Rather, the prohibited criminal conduct, which Palm refers to, is factually derived solely from the emergency order. Stated otherwise, Palm created the potential for crime by Order 28. Counsel for Palm admitted that much at oral argument, when he said there's only one element that need to be proved in a criminal prosecution for a violation, that the order was violated. Such an argument is without legal foundation and ignores more than 50 years of law, some of which cited above. Ouch. Ouch. You will follow my dictate or you'll go to jail. Ouch. As we stated at the beginning of this decision, the governor's emergency powers are not being challenged by the legislature, and Palm does not rely on the governor's emergency powers. Constitutional law has generally permitted the governor to respond to emergencies without the need for legislative approval. With no time for ex ante deliberation and no metric for ex post assessment, the executive capacities for swift, vigorous, and secretive action are at a premium. Citing a law review article. Okay. So if there's no time for deliberation in advance and there's no metrics to determine what success looks like, then the executive might have some power to do stuff on an emergency basis. But the governor's emergency powers are premised on inability to secure legislative approval needed for the emergency. For example, if a forest fire breaks out, there's no time for debate. Action is needed. The governor could declare an emergency and respond accordingly. But in the case of pandemic, which lasts month after month, the governor cannot rely on emergency powers indefinitely. Nice. Little footnote. Let's read the footnote and see if that has anything to say. The Wisconsin statute authorizes the governor to invoke emergency powers for 60 days when the governor declares an emergency, which the governor did here. We take note that 60 days is more than enough time to follow rulemaking procedures consistent with law. Therefore, emergency circumstances do not justify Palm's failure to follow the Administrative Procedures Act. However, Palm claims that neither rulemaking nor time constraints inherent to emergency powers restrict her power. Okay, so you have absolute power at all times. That's really nice of you there, Palm, as dictator. You're really loving that one. The order. The order is a general order with general applicability. Therefore, it is a rule, and accordingly, the rulemaking procedures, which protect the people, were required to be followed. Furthermore, Palm's reliance for criminal penalties to violate is misplaced. She chose not to follow the law. Ooh, ouch. Ouch. Therefore, there can be no criminal penalties for violation of the order. Ooh, look who is the lawbreaker. It's you, Palm. Ouch. Wisconsin Statute 252. 252 addresses communicable diseases. Palm relies on this statute. As already explained, Palm was in error to assert they're not to comply with the rulemaking. However, because we grant review of the second issue, we assume arguendo that rulemaking was not required and consider whether they exceed the scope of permissible action. All right, so this is cute. So we've already determined that what you did was outside of the rulemaking process. So we could just end it there because we have disposed of the issue, right? We could just end it here, but we're not gonna. We're not gonna. We're going to assume now that actually, as it turns out, this wasn't a rule, and you could just do this by your fiefdom. So we're going to go ahead and reach the second issue. We don't have to, but we're gonna. So now we're going to figure out, even assuming that you didn't have to promulgate this by the rule, were you allowed to do this? Did you have authority to do this stuff? This should be good. Palm claims the meaning of the provisions in the statute are plain. She argues that health services has the power to take direct action to control communicable diseases, just as it does through the Safer at Home order. She asserts that the statute gives the health services expansive authority to respond to a rare health crisis, like the current one. Therefore, she can authorize and implement all emergency measures necessary to control the communicable disease. In addition, Palm asserts that the order is independently authorized by the statute, which provides the health services with multiple avenues for control and suppression of communicable diseases. And finally, many of the order's provisions also fall under 252, which Palm asserts empowers her to close schools and forbid public gatherings in schools, churches, and other public places to control outbreaks and epidemics. Palm has all the power, man. Palm can do all the things. Palm is God. Okay, let's figure out if that's true. Palm asserts his broadest grant of authority is 252 because it says she can authorize and implement all emergency measures necessary to control communicable diseases. She asserts all as a modifier suggests expansive meaning because all is a term of great breadth. She argues that she does not have limitless power under the subsection because it's only in an emergency, and a statute requires an action to be necessary. Okay. Crimes created by the legislature in statute must have specificity in order to be enforceable. Because Palm fails to understand the specificity necessary to be a valid statute, ouch, she fails to understand that no less specificity is required of a rule on which criminal penalties are assigned. Ouch again. Geez, wow, we are just... Because Palm fails to understand the specificity necessary to a valid criminal statute, she also fails to understand that no less specificity is required of a rule to which criminal penalties are assigned. So Palm does not understand how specific you have to be in a criminal statute, and therefore it doesn't understand this either. Palm is an idiot. Wow, Palm is getting destroyed. Palm is getting destroyed. We've just openly insulted Palm in this opinion now. Palm is a dunderhead. That's great. If the Wisconsin statute were the sole factual foundation for the criminal charges, no criminal prosecution can be had because it does not have the specificity required for fair notice. Stated otherwise, it has no defendable standards for required or prohibited conduct. If the emergency order had been promulgated as a rule, it would have more specificity, however, but since no rulemaking occurred, the order cannot save itself. Palm next cites the statute addressing 4 concerns that permit the health services action. First, for guarding against introduction for any communicable disease into the state. Second, for control and suppression of communicable disease. Third, for quarantine and disinfection of persons, localities, and things infected or suspected to be infected by the communicable disease. And fourth, for sanitary care of jails, state prisons, mental health institutions, schools, public buildings, and connected premises. However, the order goes far beyond what is authorized in the statute. For example, the order exceeds the authority to quarantine those infected or suspected of being infected. Instead, it quarantines all individuals present within the state. That will be going further, yes. By ordering them to stay home at their place with exceptions she deems appropriate. She also prohibits all public and private gatherings of any number of people that are not part of a single housing unit. Again, this directive is not based on the people being suspected of being infected. Ouch. Palm skips over this obvious overreach and contends that the first and second provisions of the statute permit actions taken in Order 28. However, once again, Order 28 is overly broad in its prescriptions. All forms of travel are prohibited, except for essential travel as defined in this order. That is, by Palm. No love lost for Palm. If this restriction supposedly is connected to the first permissible action to guard against the introduction of any communicable disease in the state, the order goes well beyond entry of communicable disease in the state. It prevents all forms of travel, not simply interstate travel. Furthermore, nothing in the statute permits Palm to close all for-profit and non-for-profit businesses with facilities in Wisconsin, except those defined by her. She cites no authority for this vast seizure of power. Man, woof. Oof. Oof. As opposed to Palm's claims, the legislature raised legislative imposed directives that the court are supposed to follow when interpreting the scope of authority. To place this contention in context, the reader should note there's a history underlying how courts have interpreted administrative agency powers. Formerly, court decisions permitted Wisconsin administrative powers to be implied. In theory, any reasonable doubt pertaining to an agency's implied power resolved against the agency. However, the legislature concluded this theory did not match reality. Therefore, under the law, the legislature should significantly alter the administrative law jurisprudence by imposing an explicit authority requirement on our interpretation of power. So the court had previously said, well, administrative agencies, you have not only the things that are stated, but you have some implied powers. So you have some implied powers. And the legislature, who's in control of the law, right? They said, no, not so much. Not so much. And administrative agencies only have that power that we give them and nothing more. They have no implied power. Okay. The Wisconsin legislature can do that. They're the ones that are giving the power out in the first place by statute. So they can also say, oh yes, we mean exactly this and nothing more. Okay. So that case law goes bye-bye because of the Wisconsin legislature, no problem. The legislature changed the law. We can do that. This explicit authority requirement is codified in the statute, which provides that no agency may implement or enforce any standard, requirement, or threshold unless that standard, requirement, or threshold is explicitly required or explicitly permitted by statute or by a rule that has been promulgated in accordance with the subchapter. Furthermore, the statute, as summarized by a recent comment in a law review, prevents agencies from circumventing this new explicit authority requirement by simply utilizing broad statutes describing the agency's general duties or legislative purposes as a blank check. The explicit authority requirement is, in effect, a legislatively imposed canon of construction that requires us to narrowly construe the precise delegations of power to the agencies. Yeah, so the legislature thought about all that. It's like, no, these are creatures of our will, and they only have as much as we give them and nothing more, and read it narrowly. Okay. In addition, the legislature cites two more canons of construction that serve supply. First, the legislature does not alter fundamental details of regulatory scheme in vague terms or ancillary provisions. Yeah, that's true. So again, when you are you don't. There's a saying that you see sometimes in court. The last time it was used in court, I think the Supreme Court, they said they don't hide elephants in molehills, which normally that phrase is mounts in molehills. I guess we went with elephants to make it more blatant. But yes, we don't tend to do things like in subtle ancillary things. So if we have a main provision, we don't tend to like in some back corner just do it. We tend to be more explicit about it. So if you're having to reach into the dark corners of wherever in order to get out of something that's generally applicable, you're probably doing the wrong thing. So yes, we don't hide the ball. You know, we have these general principles that are here, and we're not going to hide the, oh, by the way, we don't really mean it, as some little, subsection of some paragraph that is trying to undo all that. If we wanted to undo all that, we'd be more explicit about it. So no. Second, the legislature cites the constitutional doubt principle. As the United States Department of Justice recently wrote, relating these concerns raised in constitutional issues, there's no pandemic exception to fundamental liberties to safeguards. Indeed, individual rights secured by the Constitution do not disappear during a health crisis. These individual rights include protections of the Bill of Rights made applicable to states through the 14th Amendment and are always enforced and restrain government action. With these canons in mind, the legislature interprets the statutes much differently than Palm. To some extent, Palm and the legislature are talking past each other. For example, Palm focuses on 252, which she asserts grants a broad power to health services. The legislature focuses on necessary procedural foundation that must precede health services implementation or enforcement. As the statute directs, unless a rule has been promulgated pursuant to the rule, it has no power to implement or enforce directives. We do not define the precise scope of the authority under the statute because it's clear the order went too far. We cannot expansively read statutes with imprecise terminology that purport to delegate lawmaking authority to an administrative agency. The legislature appropriately cites the statutory exemption authority requirement and has provided a plausible reading of the text. We have declared rights under the law where we have concluded the emergency order is invalid and therefore unenforceable. Although a very unusual request, on April 21st, 2020, the legislature asked this court to issue a temporary injunction for the order, but then requested a stay of the injunction for at least 6 days. We perceive this request as being grounded in a concern for orderly transition from the order to a lawful rule. However, more than 2 weeks have passed since we began our consideration of the case. Therefore, we trust the legislature in Palm have placed the interests of the people in Wisconsin first and been working together in good faith to establish a lawful rule that addresses these concerns. Sure, they have. People, businesses, and other institutions need to know how to proceed and what's expected of them. Therefore, we place the responsibility for this future making with the legislature and health services where it belongs. Sweet. Conclusion. We therefore conclude the emergency order is a rule under the controlling precedent, and therefore is subject to statutory emergency rulemaking procedures. The emergency rule is a general rule of general applicability which defines what a rule is. Accordingly, rulemakers are required to be filed. Because they're not, it's unenforceable. Furthermore, the statute requires that emergency order be promulgated using procedures established by the legislature for rulemaking if criminal penalties are to follow. Because you didn't follow this procedure, there can be no criminal penalties. The procedural requirements must be followed because they safeguard the people. We further conclude that Palm's order, confining all people to their homes, forbidding travel, and closing business, exceed the statutory authority upon which the claims rely. By this court, Palm's order is declared unlawful, invalid, and unenforceable, effective immediately. So that was done last night. And the bars and such in Wisconsin have reopened, I am told, and the people are extremely happy. So, yeah. So, unfortunately, it doesn't really speak to anything in terms of the broader principles, in terms of broader issues. I was hoping that it would speak to something that would speak to broader things, but this is pretty esoteric. It's pretty idiosyncratic on specific aspects of Wisconsin state law. So, the Wisconsin Supreme Court has read me the relevant law. They've interpreted it for me. They interpret the precedent for me. They've explained it to me. Sounds right. I mean, I know nothing about Wisconsin law, and it sounds right. I can't find any obvious logical flaws in what they're writing based on what they're describing the precedent is and so forth and so on. And Palm gets completely destroyed is what we learned from that. So, yeah, so that's pretty interesting. So that is the end of that case. So I don't know whether or not Palm is working on a formal rule at this point or not, or intends to promote one, but at least for the moment, there is this order is gone because it was invalid. So there is a way for a government to institute these orders under these procedures, and then you'd have to ask different questions, right? If you did it under the proper processes, you'd have to ask different questions that would go to some of the other issues, right? But you didn't follow those proper procedures, so we're answering these questions. If you follow those proper procedures, then we'd be asking different questions about their rationality and their tie to the situation and whether or not they're in keeping with constitutional problems and so forth and so on. But we could decide this on the procedural element. So pretty simple. Or it's honestly extremely complex. It's just the end, it's very easy to understand. So for those of you who are here, 55 of you who are here and like the stream, if you like the stream, as always, I'd appreciate it if you give it a like. If you give me support, I always appreciate any support you give. I do these things for you. I hope you like them. I hope this is valuable. And I'm going to sign off. So until later, my friends, I hope you're well. Cheers. Goodbye.